Welcome everyone to the Tonkin Legal Group, home of the Australian Family Law podcast, the AFLP. Definitely not the official podcast of the Australian Football League. We want nothing to do with them corrupt body. And it is I, as always, Joe, joined by St John. How are you, St John?
Very well, thank you, Joe.
Very good. And we got Charlie, who's up and about in the gear. You haven't beaten any of our teams, but doesn't matter. The D's are up and about.
Couldn't be more up and about, Joe. I've been trying to keep a lid on it for as long as this season, but I think it's time. It's done. It's
the
done.
lid is officially off.
It's gone. It's in the stratosphere. Going very well. Thank you, though. How you going, Joe?
It's a great effort.
Let me just go quickly to the Balti Bridge underneath it. I think to go collect that lid because I think I heard that splash over there. But very happy for the D's. Certainly, out of our three teams, the only one that is remotely likely, and we're all aboard. All of our hearts beat true. We all bleed red and blue, don't we? SH, literally and.
Well, no, not really, but no. Look, it was a great effort. I actually didn't see the last bit of the last quarter, and I just assumed that Freo would maintain their small lead. But yeah, so I think it was a really good victory, and I think for your coach, I just think he's just got that quiet confidence about him, hasn't he?
He does. He's got a bit of an aura about him, Kingy. But yeah, I was the same. We all kind of expected Freo to come hard in the last quarter, and they were up by about three or so goals at one stage.
Yeah.
It was one of those games where you're not the favourites, and you're playing against an interstate team who are on top. So it's kind of like it's a bit of a free hit. So
it's a win-win, yeah.
Yeah, it's a win-win. So we got a good run, and yeah, I don't think Freo, they didn't have a whole lot to play for, to be fair, in that game, and they were resting their captain. So, but either way, it was a good game, and we played some pretty exciting footy.
It's good for the psyche, though. It's good for the culture of your club, I think, because they can kill giants.
Yeah.
And Dockers.
And Dockers, yeah, that was good. And SH, your mob, the Tigers, you had plenty of chances in that game.
Well, I'm not going to use the phrase another honourable loss because there hasn't been many honourable losses this year apart from dishonourable losses. But look, hostile territory on the road. They were a few. Actually, they weren't that short on players, but we had a few out still. So I thought it was there. In the words of Uze, can't fault the endeavour. It's just the crux or the crucial moments where and as I said to you earlier today, Joe, or you said to me, or maybe it was you, Charlie, it was more our senior players that were mucking up. But some green shoots there. I've got to cling to all the positives I possibly can. What about you, Joe? I think your mob headed down to one of the most difficult jobs in football, and you acquitted yourselves quite well.
Yeah, can't complain. Definitely showed up Charlie in his honest prediction.
180 points.
So it was pretty funny there. It's all right. Yeah. It's you're being honest, and we all. It's a reflection of who you are as a person. So it's no, kidding, Charlie. No,
more than happy.
No, I was morbid. I was terrified. I got a bit of PTSD with the Cats. They always. They always destroy us, and we're now at a stage, unfortunately, where similar to the Tigers, we tend to be cellar dwellers, and the cellar dwellers are the ones that have to travel to Cardinia Park and play them over there. So to walk away with a 11-goal loss, I think was certainly better than what it could have been, and in what was shocking conditions, and a couple of positives really. I mean, again, similar to the Tigers, it's the youngsters, Sharp and Farrow and young Vigo Vizentini in the ruck, who, funnily enough, is the only player in the league with VV as his initials. There you go. Some little fun fact for everybody out there.
Yeah. He did good, Vigo, but yeah, I think you definitely exceeded expectations down there. And I mean, there's a bit going on down at Geelong at the moment with the contract saga. So would have been
to a nicer team.
They were due a scandal, weren't they?
Well, there's only so many you can paste over, isn't there, before they burst out. So, look, heads have got to roll on this one, don't they? Someone's got to lose their job.
Has to.
Well, AFL was trying to sweep it under the rug. Nothing to see here. Nothing bad. Nothing happened. But in reality, it's the very principle that this contract existed, that Geelong overstepped their bounds as much as they did. They basically put College Jasny in an impossible position where, and they'll do anything to play. I mean, we saw Tom Mitchell on Friday, Charlie, who in a function at a local footy club where he's now playing at Greensborough, and he said, players lie. Players will do whatever it takes to get out there to play. They'll do anything, and a lot of times these contracts are there also to protect the players from themselves. And Geelong did not do that. And the chairman of the board at that time in Geelong is now chairman at the at AFL headquarters. I mean, could you have any more incestuous connection there between these two? It's unbelievable.
No.
So the 2 points I want to make are these, because in reality, apparently the AFL were forewarned at some level. Not an official level, I don't believe, but were forewarned at some level. So they've not ticked off on it officially, but they were aware of it. And the second point is, this guy will never play footy again. They were going to move him on this year, or at the end of this season. Who on earth is going to pick up Jade Kolodajny with his current circumstances? So they've blown his career as well.
And what's his agent doing at the time? I don't know. Has it come out whether his agent was across it, or is he? It sounds like he's done it sort of on his own with the club. Like, it's just, it reeks of corruption, Geelong AFL, and just something heavy's got to come from it. But I don't know if it will.
And then, as you said, Joe, that statement that came out, what was early last week, was a joint statement with the AFL Players Association, who are meant to be backing the players. I know they're AFL funded, so there's a bit of a conflict of interest there, but they have a joint statement saying, nothing to see here. No, there wasn't a player disadvantaged at all. That's our sole reason for existing, to look after players. But they side with the AFL and say nothing to see here.
Well, who's the president of the AFLPA?
Well, it was Dangerfield. He's moved on now, hasn't he?
I thought it still was, but he probably was at the time. So yeah.
Yeah, he was at the time.
Yeah.
So yeah, I don't know. Maybe because we have PTSD against Geelong, we're digging the boots in.
Definitely. But strip them of all their flags.
Well, they're probably a little harsh. Maybe no draft picks this year and next year.
Yeah.
Oh, they're quick. They're quick to find everybody else. They're quick to drop the hammer on any other team for the most minor of infringements. You'll find them front page for whatever it is. But of course, when it comes to the Cats, I mean, they are masters of quelling things. Even the whole Stengel situation that took place, for example. How quick were they to quash things about that? I mean, they are. There's no doubt that they are an incredibly powerful, resourceful, well-run football club from that perspective. But now that this has come out, and there's been a lot of persistence in the media and from the general public about this issue, it's becoming a lot harder to quell it and to sweep it under the rug. And some might say a mediation might be required here, right, folks?
Well, what about the chap that's facing 300 defraud charges or fraud charges? Who was one of their main sponsors? Anyway, I won't comment on that. Other than that, I think the AFL needs to call an independent investigation and obviously the parties will need to mediate, which brings us to our topic today, doesn't it?
It does. It is
Very
perfect.
Last week we talked about the pre-action procedures, which is, what do you have to do before you go to court. So we're going to look a little bit more into the detail of pre-action procedures, which I think pretty clear that you need to make full and frank financial disclosure, which means each party has to swap their financials. But then there's also some encouragement to make a genuine attempt. This is the wording of the Act or the law, a genuine attempt to resolve the matter. So let's start with a discussion on a genuine attempt to resolve the matter might involve a mediation.
Absolutely, and that is going to be our rule of the game. Yes, so talking about a mediation or family dispute resolution, we had forecasted it, well introduced by you there, SH. So we'll go about, everyone sort of understands what the general principle is, I suppose, in terms of trying to negotiate an outcome. But what would we say would probably be some of those big misconceptions about having family dispute resolution in place? That, I think for me, I'll probably just say that people just think there might just be a tick of the box that they've quickly tried to have an offer. They might put something on the table. Here's $80,000. Take it or leave it, and they might consider that to be, I suppose, sufficient, genuine steps there to try and resolve the matter up front. Do you have any other general misconceptions, Charlie, about this?
Yeah, well, I was going to say a lot of misconceptions do come from, it's a waste of time. I'm not going to mediation. Let's just go to court. Well, firstly, as we know, with the pre-action procedures, it's not a matter of just going straight to court, and attending a mediation or a family dispute resolution is a big part of it. And look, it depends on the parties involved as to whether it is going to be a waste of time. But in reality, if you narrow some of the issues, or if you reach an agreement on 2 out of 10 issues, then, well, it hasn't been a waste of time. You've narrowed the issues in dispute, even if you don't agree on everything. So agreeing on 2 things out of 10, that's a whole lot more than a lot of parties do. So that's probably the biggest misconception that I would note. St John, are there any other misconceptions you'd recognise, or?
I suppose I'll come back to the definition, because we as family lawyers tend to use mediation and family dispute resolution interchangeably. There is a distinct difference, but for the purposes of this podcast, they are the same thing. They're about a process where people sit down with somebody else and engage in some form of discourse or exchange to try and genuinely resolve the matter. Family dispute resolution is available in some family dispute resolution centres, which are government-based, and they're dotted all around Melbourne. I think there's around 20 offices. We have one here in Greensborough. But mediation can also be done by a private organisation, not-for-profit, like Relationships Australia, or that can be done by trained mediators, or it can be done by a barrister, or it can be done by a solicitor who is a trained mediator. So there are various different ways of doing it, and this misconception that mediation is different to family dispute resolution in some respects is a misconception and incorrect. They both are designed to try and resolve the dispute without having to proceed to court.
Yeah, and some people might think that this is, a little bit piggybacking there of Charlie when someone says it's a waste of time. Some people might consider it to be a waste of money because, I'm not about to splash a lot of cash here trying to resolve things with my ex, who is completely, unreasonable, and there's going to be no chance of success. I'm not about to waste a lot of money in that exercise. I'd much rather just spend my money in court. Well, using some of these centres that St John just mentioned, these are fairly cost effective. There is a bit of a wait list, of course, because as you can imagine, when something is being offered, for free or very cheap, then of course there tends to be a lot of demand for those services. So, if you were to go to a private session, like if you were to look at a previous episode where we had Patricia Coggill on. She runs her own private practice, and the turnaround for that would probably be, around a week to 2 weeks, as opposed to waiting for, Relationships Australia, for example, which is, the one that's around the corner from our office here. There's a much more substantial waiting list. Obviously, you're paying a lot less for that, but time is money, some might say, or a lot of people say. So it's certainly not a waste of money or resources to try and resolve your situation where you might end up saving yourself a significant amount of legal fees in contesting it in court down the track.
And the family dispute resolution run through the family dispute resolution centres do not involve lawyers. So the parties are not there with their lawyers, they're with a social worker or a psychologist or someone who's trained in that, probably not a psychologist, but trained in that field, to just keep the parties talking. So, and that's why it's inexpensive, because you're not dragging your lawyers along who are charging hourly rates. And, to spend a day with a lawyer is an expensive pastime. So these family dispute resolution centres are a really good starting point. See if you can make a genuine attempt to resolve the matter.
Yeah.
I think it's important to mention also that these sessions don't have to be with each party sitting across the table from each other. They can be done in a shuttle sense, where the mediator moves or shuttles from room to room, and the parties can be in separate rooms. So you don't have to eyeball your previous partner or your ex-partner. And that sometimes gives way to greater discussions and involvement in a resolution, and can assist in the parties coming to an agreement.
Yeah, it's a good point, and I think that the whole idea of having that family dispute resolution practitioner in there, going in between rooms, it's an impartial third person, so they're not tied to anyone. They're not biased to either party. So it's kind of that person acts as a bit of a buffer between the parties, and can also give a bit of a reality check as well, that if you proceed down this path, then it's going to get a lot more expensive, and now's a good time to try and reach a compromise.
As you said before, Charlie, if you can get 2 of your 10 issues resolved at mediation, that's 2 you don't have to spend with your lawyer trying to resolve those particular issues. I think we did mention last week that in parenting matters, mediation is mandatory before you proceed to court, unless there's urgency or family violence. And generally, if you do proceed through the mediation process, you need to get a Section 60I certificate, which says you've been there and done the process. That certificate actually has down the bottom, which needs to be signed off by the family dispute resolution practitioner, a line that said, did the parties make a genuine attempt to resolve the matter? I haven't had one yet that's come back. Oh, no, I had one actually in some time where it said didn't make an effort to resolve the matter. So as you said, Charlie, if you go there and you sit like this and you refuse to talk or you refuse to participate, then that's going to be reflected on your certificate, which could possibly have some cost implications if the matter then has to proceed to court.
Beautiful. We then move on to Ask the Umpire. All right, gentlemen. Charlie, we both get to pick St. John's brain here, and I guess I'll start things off here with my first question to you, St. John. How does family violence affect the requirement to attempt dispute resolution?
Well, I probably touched on that a moment ago. The family violence is an exception to Section 60I of the Family Law Act, which says that you must mediate if you wish to ask the court to make parenting orders. If there is an intervention order, if there's been an allegation of family violence or child abuse, you bypass that process. So there is no requirement to mediate, and it's quite obvious why. If you're in a violent relationship, why would you want to go and sit in a room or in a mediation process that you would feel uncomfortable sitting in? That's not to say that people can't mediate when there's family violence or where there's an intervention order in place, but In this case, family violence requires you, presence of family violence does not require you to mediate before proceeding to court for parenting orders.
All right. The next question for you, St. John. Can making a reasonable offer help a party later in court?
Yes. The answer generally is yes. I'm a great advocate for cutting the bullshit and getting to the heart of the issue. Most family lawyers understand where their client's position sits, where a percentage generally sits, or the range of a percentage. So I think there's some merit in making a proposal that you can live with, but that puts it in the percentage range, which makes the other party feel uncomfortable for them to bat on.
It also can be pretty good with a. You go for it, Charlie.
No, I was just going to say it can be in the form of a without prejudice offer, and we know the importance of that. So you're not held accountable to that offer later on in court, but also it can have some positive cost implications if you achieve an outcome similar to or better than later on in court. Sorry, Joe, I talked over you before.
No, I was literally going to say it could come in very handy down the track for potential cost application, especially if it was in the form of a colder bank. That's something that we will discuss in future episodes. We'll then move on to fact or furphy. Here we are, SH. Now you get to ask one of both of us, I guess. You get to ask both of us a question there. Yeah, not just one of us. I'm not gonna hog on all the questions here.
Okay, Joe. I need to ask you a question about mediation. So, if I might read the question from our running sheet here.
Sure.
If the other side refuses to attend mediation, am I stuck?
No, that's you're not stuck. You sort of mentioned it previously as well. There is that little bottom line there on the bottom of the Section 60I certificate, which very rarely, I haven't had it either. I haven't come across my desk where I've got a Section 60I certificate where someone has been deemed to have not made a genuine attempt to resolve things, even when they've stormed out before lunchtime and they haven't made any, they haven't made any, and even then it still didn't get ticked off. So that certificate certainly goes a long way towards taking the matter to court, enabling you to be able to issue proceedings in court. You should never really have any qualms about inviting someone to a mediation to try and resolve things, because obviously it puts a timer on. You start to have an intake session. You're showing that you're complying with all of the pre-action procedures, so that when you go to file, again, that'll probably be in our next episode, a genuine step certificate, you can tick that in full confidence, knowing that you have invited them to mediation, you've made inquiries with an accredited family dispute resolution practitioner, and there will be no cost implication against you in that respect if you were to proceed with an application. So no, you are not stuck if the other party is not doing anything. All they're doing is increasing their risk of running a cost application against themselves.
I think the bottom line is, if the other party doesn't want to turn up, then you just ask the mediator to provide the certificate, which is your ticket to go to court. Yep. So it's just it's an option that you should exhaust if appropriate, and where there isn't family violence or urgency. You should exhaust first before you proceed to court. As you say, you look better in the eyes of the court. Now, fact or furphy, Charlie, sending one angry email counts as a genuine attempt to resolve the matter. Fact or furphy?
Unsurprisingly, that's a furphy. Although it may be quite satisfying sending that email. It's probably not a great idea.
Keyboard warrior, yeah.
Exactly, yeah. Get it out of your system, and then no. So that's a furphy. I mean, it's by nature that's not really a genuine attempt to resolve the dispute. So Yeah, provided that none of the exemptions apply, you'd need to go through, for parenting matters, try and go through a family dispute resolution or a mediation, and then for the property side of things, you'd still need to comply with those pre-action procedures and put forward a genuine offer or attempts to compromise. So no, just sending that angry email. I mean, unless there's some productive things said in that email when it comes to putting forward an offer to settle or placing the other side on notice of an intention to commence proceedings. But I don't think that was what was included in that angry email that you were referring to, SH.
So there's a step process here, isn't there? You can't immediately knock on the door of the court unless there's violence or urgency. You need to follow the pre-action procedures. You need to attend mediation, especially or more particularly for parenting matters, and you need to tick these boxes. And as you said, Charlie, then and only then, once you've ticked all those boxes, you need to then advise the other side of your intention to commence court proceedings. So I think for the general people listening to this podcast, the idea that we're trying to get across here is that it's the court's view that you should exhaust all avenues or options before knocking on their door.
Yeah, absolutely. And we now move on to play on or blow the whistle. Gentlemen, there are heaps of different types of mediation techniques, one of which being, discussions between yourselves. I mean, there was that angry email from the previous section. Another time you could have been sitting around in the kitchen having a discussion. So you've got two people who are having a discussion, a kitchen table discussion, you could say. They're trying to discuss, they're trying to mediate, they're trying to come up with some terms as to how they can resolve their property matter. They're unable to do so. They have one session. They sit there at the dining table. It doesn't work out. The husband storms off, and the next day issues proceedings in court without further notice to the wife. Play on or blow the whistle?
Charlie?
I'm going to blow the whistle on that one. I mean, again, it will depend on, like what St. John was referring to earlier, on if there's any issues of urgency or family violence, then it might get through the gate. But I don't think in that instance that example, Joe, that you referred to is truly a genuine attempt to resolve the matter. Sure, you've tried to sit down at the kitchen table with your ex-partner and you've tried to resolve it. I think you need to take a few more steps, go through a mediation or a family dispute resolution to actually make it a genuine attempt to resolve the matter before filing a court application.
And I think it's what the court recognises as a genuine attempt, and it doesn't recognise the kitchen table method, unfortunately. So I'm calling blow the whistle on that. Doesn't mean it doesn't work. I always recommend to clients, if you can resolve your matter between yourselves, then you're more likely to have some sort of friendship moving forward, if that's at all possible, and you're more likely to be happy with the result. It's when lawyers and courts get involved where people start to get angry and bitter for obvious reasons.
Exactly. And if you sit down, and we're not saying that you should not be having that kitchen table discussion. Absolutely. If it is safe to do so, you are encouraged to do that. And where you can negotiate on an equal playing field and not one where one party is I suppose cowtailing or to the pressure of the other party or overbearing. Yeah, thank you. So whilst there is a level playing field and both parties are able to express their thoughts and their opinions amicably, then it could be very well possible that you could end up organising for a consent order application to be filed. But in this instance, you can't just rush to court from a kitchen table discussion. We now turn on to our honest predictions. All right, honest predictions. We'll start off with the Richmond Tigers. They play first out of our three teams. They're playing against the Saints at the MCG on Saturday. 12:35 p.m. And dare I say it, St. John, and I'm being honest because I'm always honest, but this is honest predictions. I'm actually going to tip the Tigers to win this one.
I think you could be right, Joe. There's no Nazaya Wanganeen. He's done his hemi.
Yep.
I just think we're up and about. We're back home on the G.
Yep.
Lynch might finally kick a goal instead of a behind, now that he's re-signed for another 12 months. So I think, yeah, and look, St Kilda's done it to us. In our strong years, they for some reason used to flog us. By 10 goals one game, I can recall, not that long ago. But look, they're going to be hard to beat, but I think we can do it. And my honest prediction, we win by 5 points.
Honestly, and I'm not just saying this because you both have said it, but and Joe and I was speaking about this earlier. I think Richmond will win this. Saints, they don't have Nazaya, and they can't make a wild card, so they don't really have much to play for.
True.
Whereas the Tigers are coming off a game they probably should have won, and you want to. I don't think you can go up or down on the ladder, so it's not as though you need to win or lose, but you want to win for Ooze. So I'm going Tigers by 3 points.
Whew. Up and about the Tigers.
I'll say Tigers. Right. I'll say Tigers by 7. I tipped Tigers. I didn't actually give a margin. I'll say Tigers by 7. You only lost to one ridiculous Isaac Rankin performance.
Yeah.
Fair to say, the Saints don't have anyone. Yeah, the Saints don't have anyone of Isaac Rankin's caliber, especially with Nazaya out. Yeah. So up the Tigers. Come on, Timmy. All right. We then move on to Melbourne. They have to cop the trip to Adelaide Oval to play against Port Saturday, 8:10 p.m. And it's hard to tip against the Demons, in my opinion, after that stirring victory. And the record away from home leaves a lot to be desired. But you know what? I'm going to tip the D's to win this one. D's win this by 17.
It's a blowout for me. I reckon the D's are up 10 goals easily. Port are a mess after Sydney's decimation. 10 goals. The D's have got their steam up and they're ready to go.
I'd love for it to be 10 goals. I'm gonna go with D's by 14 points and Tom Sparrow to sign a contract extension 2 days before the game with the D's.
Yeah, well, I think you're selling yourself short there, mate.
Yeah, it's probably just a protective mechanism I'm using.
It's just to put the mask on.
Yeah.
That discussion you raised there, talking about the signing on. Did you see how Tassie announced that they had Cadbury sign on? With Ken Hinkley. Ken Hinkley calls up Brendan Gale and says, "We've got our first signing, big signing. Who is it?" And he's just there eating. He's just eating a Cadbury chocolate. And he wouldn't tell him who it was. And Gale's trying to think that it's a player, but in reality, it was Cadbury chocolate. So
Gary Lyon's view was that Hinkley was overacting and that he needs to calm himself down. But have you heard the rumour Hopper to Tasmania for a round 1 selection, and we'll pay his wage?
Good deal for you guys. Very good deal. Yeah,
that's what Hurdy said on Friday as well, Charlie. That the Tassie are looking to almost do a reverse salary dump where they will give away because they're required to trade some of their first round selections, and so they're basically shipping them off to anyone who's willing to give them ready-made senior players. Of course, if they're going to pay, pay their wage, exactly. Yeah. And so it's a win-win. The Tassie Devils, they get senior ready-made players, and the other team gets that player off and replaces them with a high pick. So very shrewd operations there from Tassie, and then we end up with the graveyard shift on Sunday at 4:40 p.m. at the MCG between the Bombers and the Swans, who are rampaging into finals. look, we were wrong for 2 weeks in a row about the Bombers. They've seemed to have done better on the expectations, but you just know, third time lucky, this might be the time that we get blown off the stratosphere. So I'm going to say the Swans by 75.
Yeah, I'm scared. I'm scared about this one, Joe. The only thing going against or going for you is it's at 4:40 on a Sunday, and Sydney might be a little bit perturbed by that timing, and it might be cold and wet. Oh no, I can't see you blokes getting anywhere near them. I'm sorry. I'd have to agree with you. In excess of 70 points.
Yeah, I think I've been very harsh on you, Joe, the last 2 weeks since we've been doing these predictions. I went, I do 88, and then last week 180. I don't think I can do 3 figures, but I might do 98 points for the Swans. I'm sorry.
Let me just pull up the calculator real quick. I want to see what the average losing margin that Charlie's had us to lose by every week. So you said 88 plus 180 plus 98 divided by 3. So you've got us losing the last 3 weeks on average by 122 points. Tell us how you really feel about the bomb race, Charlie.
Funnily enough, I'm optimistic about your youth, but I think right now you've packed it in, which is fine.
Yeah, I think put the Q in the rack, haven't they? Yeah.
It's been in the rack for a good 10 weeks.
Before we go, guys, I just wanted to catch up with you. You had a good Friday afternoon at the Greensborough Football Club with Jimmy Hurd as the guest speaker, and who was the other chap?
Tom Mitchell.
Tom Mitchell,
was it? Tom Mitchell, yeah. Yep. Good afternoon.
Great afternoon, yeah. Yep, invited by our friends at Jealous Craig, Brett and Dean. So, yeah, no, it was a very good afternoon. Got some good insights from Hurdy. I'm not sure what Joe's doing right now, but here we go. Joe's going to show you a little gift he walked away with from the day.
A signed scarf from James.
Scarf from James. It's got James' signature on it. Yes.
Is that from Jack Ross? Was it?
Jack Ross. No, it's
from James.
James's signature. Yes, that's right. It's from James. So
it is from James.
It's James, twice. Isn't it?
Yeah. Shook his
Joe
hand
hasn't
twice.
stopped smiling since he got back Friday afternoon. It's good to have those little sessions and have a break from work and listen to some true AFL footballers talk. And he's on the cusp of something pretty big if it all happens the way he says it may happen. So you might be on the ground floor of a new decision, guys.
The interesting thing as well is that the person who was interviewing him, TL, he is the runner for him at Port Melbourne. And Jimmy said to him, if he gets appointed as the coach, he's going to bring him along as a runner. And I spoke to him afterwards, and he said, let's keep in touch because we'll be in the rooms every week. So, come on, Jimmy, please become a coach.
Yeah.
Have you turned your mind around to the concept now? Have you, Joe?
I now have a vested interest in this, so I'll say yes.
Wow. Yeah. Okay.
Charlie was convinced too.
I was drinking the Hurd Kool-Aid the whole afternoon. I'm sold on Hurdy.
I heard it was VB, but
that was Carlton draft.
Carlton draft. No, he's very persuasive, Hurdy, and I'm sold on his aura. He just had a presence about him that I bought in. I'm all in on it.
Well, there you go. Well, he reckons you can get Toby Green and win a final in 3 years.
Get around us. Get around us. Yeah. You gotta have big plans. Got to dream big. Aim for the moon. You might hit the stars. I don't know why that's a saying. The stars are further away from the moon. I don't even know why I even said that. On that note, guys, if you enjoyed what you had to see or hear from us today, please like, subscribe, hit the notification bell to not miss out on any of our episodes that we drop every single week. If you're listening to us on Spotify, please rate us 5 stars. These things are very small and very free and very easy to do, but for us, it goes a long way to continue to expand our presence and to permeate through the media and the general public so that we can continue to break down and demystify family law for everybody. St. John and Charlie, it is, as always, an absolute pleasure to do this with you guys.
Thanks, guys.
Thank you, Joe. The feeling's mutual. Thanks, Charlie.
Absolutely. Go D's.
And we'll see you all in the next one. Go to me.